Good morning, good afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's webcast, Oil States and SAS, Takeaways from the Live Arguments Before the Supreme Court. I'm Rachel Emsley, and I will be your moderator today. It's my pleasure to welcome our presenters, Kara Laswell, Jason Stack, and Trenton Ward. Kara Laswell is an associate in Finnegan's D.C. office, where she focuses on litigation in many forums, including inter partes review proceedings before the Patent Trial and Appeals Board, where she has been counsel on both the patent owner and petitioner side. Kara is a summa cum laude graduate of Washington and Lee University School of Law, where she served on the Law Review as an editor. We are fortunate that Kara attended arguments at the Supreme Court this past Monday, and she'll share her insights with us today. Like Kara, Trenton Ward also attended Monday's argument. Trenton recently joined Finnegan after serving for 5 years as a lead administrative patent judge at the Patent Trial and Appeal Board. As a judge at the PTAB, Trenton adjudicated more than 250 AIA trial proceedings, including inter partes review. We are pleased that he is willing to share his perspective and insights from attending Monday's argument with us today. Jason Stack is a partner in our Atlanta office and is the leader of Finnegan's PTAB trials section. He has been lead or backup counsel in an amazing over 85 PTAB trials and has consulted on dozens more. He also represented clients before the U.S. Court of Appeals for the Federal Circuit in appeals stemming from PTAB trials and district court actions. Among his many posts, Jason currently serves as the PTAB Trials Committee Chair for the PTAB Bar Association. Before I turn things over to our presenters, I invite everyone to participate by submitting for a live Q&A session later in the webcast. Just click on the red Q&A button at the lower center of the webcast interface and type your question into the Q&A window. Then click Submit. You may enlarge the slide window at any time by clicking on the green Enlarge Window button at the top right side of the slide window. The slides will advance automatically throughout the event. If you're experiencing any technical difficulties at all, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now let's begin our presentation, Oil States and SAS, Takeaways from the Live Arguments Before the Supreme Court. Welcome, Kara, Jason, and Trenton.
Thank you. This is Jason Stack, and I'll give you a few facts here. Thank you for joining us first, and I'll be talking a little bit about the facts behind Oil States. You really don't need to know very much as far as the constitutionality questions go. You should see on your screen some information about it. We had Oil States sued Greene's Energy for infringement of a hydraulic fracturing patent. Greene's then challenged two claims as both being anticipated in an IPR before the PTAB. The PTAB then found both of those claims unpatentable. There was a motion to amend, and that was also part of the cert petition, but was ultimately denied. The only question that was granted related to the constitutionality under Article 3 and the Seventh Amendment question. But if we look at the question as it was framed when the court granted cert, the question was whether inter partes review and adversarial process used by the Patent and Trademark Office to analyze the validity of existing patents violates the Constitution by extinguishing private property rights through a non-Article 3 forum without a jury. And that was, the petitioner framing the issue as best they could, but it brings in notions of separations of power, private property rights versus public, and a number of other issues that we'll talk about that the Supreme Court seemed to be interested in talking about. There were 58 amicus briefs filed in the Oil States case, and you can look at the list and you'll see that there were a number of interesting things about this case. One is that there were a number of law professors coming out on both sides of the issue, both in favor of constitutionality as well as against constitutionality. There were some things that I thought were kind of interesting. For example, IEEE supported the petitioner, saying that IPRs are unconstitutional, while a number of IEEE's members, including Apple and Dell and so forth, a number of these electronics companies, Intel, were on the opposite side and said that they like these proceedings. They think they're constitutional. So I think it sort of highlights the nuances that this issue presents. Some parties that you might think would fall on one side or the other, it's not always the clear-cut line that we might have thought we would see. Certainly for some entities that, are in the business of challenging patents at the PTAB, you would expect them to be on the constitutionality side. But for a lot of the practicing entities, we see them falling on both sides of the equation. In those amicus briefs, there were a number of different topics that were raised. We'll get into some of those more specifically as they relate to the justices' questions. Just sort of generally, some of them focused on the value of IPRs in the overall scheme of the patent system. Some of them honed in on the public versus private rights aspect. Some focused on history, looking back to how invalidity or unpatentability actions were prosecuted, back in the 1700s and earlier. Some of them tried to draw lines between pre-AIA patents and post-AIA patents, looking more at questions of maybe notice and due process, that type of thing. And we'll discuss some of those in more detail below. But for now, I'm going to turn it back over to Rachel to talk about some interesting statistics.
Sure. Thank you, Jason. So I tried to do an analysis of the transcript when it came out shortly after the argument. And I think people have done this many times in the past to try to make predictions about which way the justices are going. But my objective was to evaluate the transcript objectively and numerically and see what we might take away from the argument. I counted questions, actual questions, and tried to exclude comments by the justices to each other or statements or restatements of a party's answer by the justices. And in the end, for Oil States, counted 77 questions, and these were actually evenly split between the petitioner and the respondents when you add the two respondents together, Greene's Energy and the Patent Office. So neither party really took more heat than the other with 49 to 51%. What was very different is who was questioning each party. The questions to Oil States came predominantly from Justices Sotomayor, Kagan, and Ginsburg. Can we take anything away from the fact that amongst those three, we got 50% of the questions? You'll see in a few slides that we have a prediction for you on how this might go out, and we do think that potentially they could be ruling together in favor of constitutionality, to give a little preview. And on the other side, Justice Gorsuch and Roberts did more than half of the questioning of Greene's Energy and the PTO. And I think you've probably seen many articles on this, that Justice Gorsuch seems to be in favor of the proceedings not being constitutional. And overall, although you can't really tell from the percentages, Justice Gorsuch really dominated the conversation in a lot of ways. So what were the justices interested in? I categorized each question to find out the answer to that question. And surprisingly, or maybe unsurprisingly, there's one issue that didn't come up, which is at least directly the Seventh Amendment. And the top issue here was whether there's a taking, if these are constitutional proceedings and the PTO can invalidate a patent in an IPR, is this an unconstitutional taking from the patent holder? And if they have relied on these patents and spent millions of dollars in investments relying on these patent rights, is that constitutional? Second in line was questions distinguishing reexamination procedure, which has been going on for a long time prior to the AIA. The PTO did have the authority to invalidate patents post-grant via ex parte and inter partes reexamination. And then the questions sort of went down the line of public versus private rights, took a lot of questions. And then I think many of us were surprised about the panel stacking concerns of some of the justices about whether it's okay that the director can change the panel midstream or add to the panel midstream. And then along down the road, there are many topics that the justices discussed, and I think that the biggest takeaway from the variety of questioning here is that there are many issues, or at least several issues, that could potentially be dispositive for one or more of the justices. And so sitting in the audience, Kara and Trenton had a front row view of these proceedings and how the justices were feeling during the arguments. And so we're going to hear from them next on what we think the ultimate conclusions might be and why we think this is so. So I'm going to turn this over to Trenton.
Thanks, Rachel. Yeah, it's great to join in the discussion of what has been a very eventful week for those interested in the PTAB. And I can tell you from my personal perspective, standing outside the Supreme Court in the cold with a few other attorneys in the bar member line at 6 a.m. on Monday morning, I would not have predicted not only the level of interest from the bar as the Supreme Court bar member line extended at one point long enough that I think more than half of the attorneys that were in the Supreme Court bar member line were unable to get into the courtroom for the Oil States arguments. But I think more importantly, I would not have predicted the level of interest from the justices, as you've seen in the sort of Rachel stats on the statistics here. But it seemed to me that the majority of the justices came in eager to ask questions about their case, about the Oil States case from their own particular perspective. And for portions of the oral argument, it seemed that there was more talking amongst the bench than argument from the attorneys. But in analyzing the questions from the justices, as you see in our chart here, we made an attempt to try and determine from those questions whether there were any justices that seemed to tip their hand as far as which way they might be leaning, whether IPRs are constitutional or whether they are unconstitutional. And you can see that on the unconstitutional side, we have put Justice Gorsuch in that box. But on the constitutional side, this group, the four of us here talking to you today at least, believe that there are three justices who seem to be in favor of a determination of constitutionality of these IPRs, and those are Justice Sotomayor, Justice Kagan, and Justice Ginsburg. And it was Justice Ginsburg that started things off shortly after Ms. Ho, the attorney for Oil States, finished her introductory roadmap. Justice Ginsburg jumped in with the question, which I found to be interesting, and she asked this. I'll put the question up here on the slide. There must be some means by which the Patent Office can correct the errors that it's made, like missing prior art that would be preclusive. So do you recognize any error correction mechanism? And Ms. Ho's answer to that particular question was that ex parte re-exams are permissible, and I believe that Ms. Ho later answered that Oil States' position was that inter partes re-examination would also be permissible. And interestingly enough, Justice Ginsburg referred back to this later on when hearing argument from the Greene Energy attorney. Justice Ginsburg described this answer from Ms. Ho as a concession that re-examination is permissible. And Justice Ginsburg also made a statement during the Oil States arguments that IPR is for, she said, a limited purpose. And she also made this statement that it's not a duplication of an infringement action. It's a narrow kind of reexamination, that it's only for the prior art right, and there are other restrictions. So it's not geared to be an error correction mechanism. So it's geared to be an error correction mechanism and not a substitute for litigation. So at least Justice Ginsburg seems to be indicating from her questions there that she's finding IPR to be more similar to ex parte reexamination or perhaps inter partes reexamination than different. Similarly, Justice Kagan stated that it's the government trying to figure out whether it made a mistake by granting the patent, which the government sometimes does and knows, but the government wants to put in place a set of procedures that will actually increase the government's accuracy in figuring out whether it made its mistake. And Justice Kagan seemed to be approaching it similar to Justice Ginsburg, as an error correction mechanism on behalf of the office. And she also made the comment that formal adjudications are all over the place in agencies, and asked the question as to how this particular one, inter partes review, would be different. Justice Kagan later on in the argument made a statement that the IPRs involve listening to a third party that has some interest in the proceedings, so it seems a bit odd to say that the government can can conduct an ex partes reexamination, and the government can allow a third party to request it, but there's some line that falls short of what the government thinks of the procedures that enable the greatest accuracy. I think Justice Kagan seemed to be struggling with this point of trying to draw this line, and she actually asked that specific question of Ms. Ho. She said, so what's the line? Is it discovery? Is it participation in the hearing? She was searching for some sort of meaningful distinction between a ex parte reexamination or an inter partes reexamination and an inter partes review. And it seems as if she's struggling with how one would be able to distinguish reexamination as constitutional and at the same time determine that inter partes review is unconstitutional. Justice Sotomayor, similarly, I think had some questions along these lines, and she seemed to be, in her questions, struggling with drawing a distinction between reexamination and inter partes review. She made this statement that there's always an inherent burden of production. You can write the PTO and say, I think this patent's invalid, period. You can't write them and say, I think this patent's invalid, period. You have to supply them with a reason for doing what they're doing. And Justice Sotomayor seemed to be implying in this questioning that regardless of the format, that the proceeding begins with a third party making a request and providing the basis to the office upon which perhaps an unpatentability determination would be made. So in our minds, the group speaking to you here on this webinar at least, we think that it's likely that these three justices, Sotomayor, Kagan, and Ginsburg, seem to be leaning towards constitutionality. And I'll turn things over to Kara to talk about the justice who seems to be leaning in the other direction.
Thanks very much, Trenton. So as we said on one of the earlier slides, Justice Gorsuch seems most clearly skeptical of constitutionality. He asked a number of questions, as you can see on the slide in front of you, getting at the point that perhaps the court's past precedent, and particularly McCormick and American Bell, could resolve this issue going forward. And he was the most willing, it seemed to us, of any of the justices to really buy into that position. Justice Sotomayor, in particular, took issue on petitioner's interpretation of those cases and seemed to view them as more statutory. But Justice Gorsuch, at least, seemed inclined to view them as constitutional and perhaps dispositive. As I said, he was really the only justice that clearly indicated that he was aligned with that position. But Justice Gorsuch also expressed some concerns that were more widely endorsed by other justices. In particular, the panel packing and the reliance or takings issues that Rachel highlighted on an earlier slide, those made up over a quarter of the justices' questions. And from Justice Gorsuch, as they were phrased, and just in conjunction with his point on McCormick and American Bell, they did seem to indicate that these concerns were leading him to think that the IPR provisions were likely unconstitutional. Now, as I said, other justices did ask questions on these points, and I think we can expect to see some discussion of both in the court's opinions. But it was difficult to predict, even for the other justices, that asked questions on these points, how they would come out in the end. Chief Justice Roberts was very quotable and very pointed in his questioning on both the takings analogies, as you can see on the next two slides, and in particular on the public interest relying panel stacking issues. On slide 22, he drew laughter from the courtroom when he asked what exactly the government and the respondents meant by judge. But in past cases, Justice Roberts has been willing to defer to Congress and to the administrative agencies on how they structure these programs. And other justices who asked questions on these issues, for instance, Justice Breyer's, also expressed concern that agencies do this kind of thing all the time. He seemed very concerned that if the court decided in favor of Oil States, he might be jeopardizing a number of other agency proceedings unintentionally. And so though he asked, as you can see on the next slides, a number of questions on reliance issues and seemed very sympathetic to patent owners who may have invested large sums of money and only to find their patent invalidated, the larger implications of a decision of unconstitutionality did seem to bother him. And similarly, both Justice Kennedy and Justice Alito, who spoke very little in the proceedings, did express some potential leanings that Congress should be allowed to limit how patent law shakes out. Justice Kennedy, as you can see, asked, well, couldn't Congress just limit the life of patents? A question that perhaps was read slightly differently by counsel than Justice Kennedy intended it. We actually had a discussion on our end while making up the slides of whether he had meant reducing the life of existing patents by 10 years or whether he meant going forward, whether it could reduce the life of patents by a number of years. And that was a point that Justice Roberts actually raised briefly on the IPR provisions, but that didn't get a lot of airtime from the court, whether IPR's retroactivity made a difference in this analysis. But at least Justice Kennedy did seem to think that Congress had power to limit how patent law will play out. And Justice Alito similarly, though he was a little bit concerned by panel packing, but Justice Alito similarly thought that perhaps Congress didn't have to create a patent system at all, and that they would be able to shape the patent system they did create as they wanted to. Jason, I think you had some thoughts as well.
Yeah, my take, I know on that earlier slide we had, I'll put it back up here, the scales of justice here. If you look at the unclear category, my take is that Breyer seems to be leaning more towards the yes, it's constitutional side. I also think that Alito's question suggests that, and it really was only one or two questions that Alito asked, so it's hard to read in too much, but they did seem to suggest that he was leaning yes in favor of constitutionality. I think Roberts was leaning no on it. He had those some of the panel stacking concerns, and then his joke, I guess, when the counsel mentioned the chief judge, and he said, "What do you mean?" And they said, "Well, the chief judge of the PTAB," and he said, "Is that an executive employee that you're talking about?" And they said yes, and he said, "Well, usually we mean something different when we say the word judge," and it was, I think, probably too harsh. I mean, the names of administrative law judges has judge in the name of their title, as Congress gave that name to them. So, but I think it is indicative of his viewpoints potentially on which way he's leaning. And then it's hard to know then, I think, for Justice Thomas said nothing as usual. My sense is that we're looking at probably a 6-3 or a 7-2 decision in favor of constitutionality here. But again, we with all the caveats, I mean, it's so difficult to predict based on the small number of questions, and some of the justices didn't really wear their positions on their sleeves entirely. And then you have folks like Kennedy who asked questions that were helpful to both sides, really. So, but if I had to stake a guess, I'd say 6-3 or 7-2 in favor of constitutionality. And one other thought I had is, that what I just said may not jive with what you've read in the press. A lot of the articles, some will talk about it being a divided court and that sort of thing, but a lot of articles seem to focus a lot on Justice Gorsuch and the negative comments against constitutionality that he had. And who knows, maybe the court will go that way. But I think part of that, I think there's maybe a couple of reasons for that. One is he had the disproportionate amount of airtime, asking the most questions, and also being sort of the most the clearest in which side he favored. I mean, he said he thought McCormick already settled the question. He had other concerns. So McCormick being an old 1800s Supreme Court case that said that courts need to hear invalidity disputes. And then there's some question of whether that was a constitutional holding or a statutory holding, and he seems to think that it was a constitutional holding. And so he thinks that apparently resolves the issue. So he had a lot of airtime and was very pointed in his comments. But I think also a lot of folks coming into this thought that the justices were primarily leaning towards constitutionality. I think a lot of the write-ups suggest that. Most of the media, I think, that I've seen suggested that. So when the argument was more heavily focused than people expected on the opposite side of that, I think it was really surprising to people. And so anyway, I guess I just wanted to explain why I think that the view that you might have from reading articles and so forth might not quite align with the view that I personally have of how this will come out. And certainly, I guess, what you see on this slide right now is the view of everyone on the call here. So,
and Jason, let me just add to that as far as the perception, and it's it sounds like the most people's perception was that the justices would be more in favor of constitutionality, and perhaps there were more questions on the unconstitutionality side than many people expected. And one of the things that seems to lead into that as well, and it's actually borne out by our data with respect to the questions that were asked, but there were a number of justices that were asking about due process violations. Roberts certainly comes to mind. I think that seemed to be the primary thing that he was asking about. Kennedy's questions, I think, can be in some part read as due process inquiries as well. And Breyer also, with his questions about 10 years, $40 billion. Breyer actually, I believe, in one of his questions noted the fact that it wasn't actually that the due process issue had not been raised and was not before the Supreme Court in the Oil States case. So I think perhaps some of the concerns by the justices questioning constitutionality were more closely related to due process concerns rather than the Article III issue that's actually in front of the Supreme Court in this case.
Thank you, Trenton and Kara and Jason. I think that it was a very interesting argument, and although I didn't get to attend, in reading the transcript, I thought that Justice Sotomayor's position was very clear as well, where she said, let me just push to that slide here. Having a little difficulty. But she said, what saves this for me is judicial review. And I think that was seconded by at least Justice Ginsburg, who thought that judicial review of the decision was important. Jason, I have a question for you. I don't think it was borne out exactly in the argument how this decision that IPRs are not constitutional, if it is to go the way of Justice Gorsuch, how that would affect existing IPR opinions in validating patents.
Well, I think there's an option, I guess, is one way to put it, for the Supreme Court to make it retroactive or to make it only prospective. The way that this came up in a bankruptcy case, it was a similar kind of issue. There was a separations of power issue raised back in 1982. It was actually a statute passed in 1978 that gave some authority to bankruptcy judges, which were Article I judges, that someone claimed was actually solely within the power of Article III judges. And the Supreme Court agreed and found there was a separation of powers Article 3 problem with that. And they found in 1982 that it was unconstitutional. There were a couple of interesting things, though, that happened there. One, they decided to apply the relief prospectively only. They didn't have any retroactive component, but they gave a little bit of a framework, citing back to an earlier Supreme Court case. But they said there's three considerations that they recognize in their precedent as properly bearing upon the issue of retroactivity. The first is whether the holding in question decided an issue of first impression whose resolution was not clearly foreshadowed by earlier cases. So that's factor one. Factor two is whether retrospective operation will further or retard the operation of the holding of their case. And then the last is whether retroactive application could produce substantial inequitable results in individual cases. And they weighed those factors in this Northern Pipeline case in 1982 and said making it retroactive was not going to serve the interest of any of those three factors, and they made it prospective only. One thing that they did, though, is the decision came down in June of 1982, and they stayed their judgment until October of 1982, giving Congress about a little over 3 months to put in place, they said, to allow them to reconstitute their bankruptcy courts or to adopt other valid means of adjudication without impairing the interim administration of the bankruptcy laws. So if there's an unconstitutionality finding, they could find that these factors weigh in favor of retroactivity. I suspect that's not going to happen. Stare decisis and those kinds of notions tend to weigh out, tend to win out in this type of situation usually, but it is possible that they could make it retroactive. But even if they make it prospective, there's likely to be some interim window where Congress can try to cobble together a new system that would be constitutional within the framework of whatever the Supreme Court gives them in the Oil States decision.
Thank you. As a follow-up question, since we can't be certain of the outcome, as unsatisfactory as that feels, while we wait for the decision, what are some practical steps for parties involved or becoming involved in IPRs in view of the oral hearing and what we have seen?
This is Jason again. It's kind of a binary thing, is the way a lot of people think about it. It's either constitutional or it's not. But there are some things that I think we've learned from the argument and some other issues that the justices seem to be concerned about that I think do lead us down some paths here. One thing for sure is if you think these are unconstitutional, preserve that argument. I don't know that you necessarily would need to if they're unconstitutional, so be it. But one thing that you may want to preserve, if you're dealing with a non-AIA patent, one that issued before the AIA, there was some discussion during the oral argument of whether there's a potential due process issue or a notice type issue where someone got their patent before the AIA was enacted, not knowing that IPRs would ever come along, and is it really fair to take that patent during an IPR? So they're trying to draw some lines and say that maybe they would find that for post-AIA patents that IPRs are constitutional. I'm not sure that will work because re-exams have been around since 1980, ex parte anyway, and inter partes since 99. The expectation of a patent owner is that you might end up having your patent claims canceled in one of those proceedings. So and these are slightly different, obviously, proceedings, but I don't know if they're going to be able to draw those lines that cleanly. But that's something to consider, is at least raising that argument. This is a pre-AIA patent and it's unconstitutional as applied to this patent. Another thing that you can consider is telling your investment story. A lot of patent owners will do this anyway, but Justice Breyer in particular had some questions signaling his interest in that angle, where if someone has invested $40 billion in some technology, at what point are they able to just rely on the fact that they have that patent right? And is there some way to quiet title to that, or is there some equitable angle here? I'm not sure that there are enough justices who would go down that path. It starts to get a little difficult to parse out. As a judicial matter, I think maybe Congress could try to do something similar to what the ITC has with their domestic industry requirement, things like that. Potentially, there might be some legislative answers, but it's something that may come up in the future, and they may not even address it in this case in Oil States, but because at least one justice was interested in it, maybe you preserve it for the next case, and maybe you try to take it up to the Supreme Court, saying I invested a massive amount of resources in this patent, and now you're trying to take it away, and that's not something that should be within the power of an Article I court like the PTAB. And then the last point I'd make is, given the concerns that were raised at the argument about due process, you should probably ask if you think that something's going to benefit you, some additional argument, some additional briefing in a PTAB trial. It seems to me that the PTAB will now be more receptive to granting that, even than it has been in the past. I think many PTAB judges were at the argument, and I suspect nearly all of them have read the transcript by now, even if they weren't there. And my guess is that the message has been received loud and clear that the justices are, at least some of them, are concerned with the procedural side. It may be constitutional from a power standpoint to have an Article I court adjudicate this, but is the right process being provided, and is due process being provided in these proceedings? And so I think you may be more likely now than before Monday's argument to have those types of requests for additional briefing granted.
Thank you, Jason.
I'll turn it back.
Thank you. I think we need to move on to SAS. We did say we were going to cover both cases today. It seems like perhaps even the more interesting question about what petitioners should do right now might hinge more on the outcome of SAS. So, Kara, would you like to take us into our second case?
Sure. Thanks, Rachel. So the dispute in SAS is another one where you don't need a lot of the factual background to really understand a Supreme Court case. But briefly, SAS was sued for infringement, and of note, the complaint in the district court case alleged that SAS infringed at least certain claims. So at the time SAS petitioned for inter-parties review, it chose to seek review of all 16 claims of the asserted patent, effectively to ensure that whatever claims were eventually finalized in the district court proceeding would be covered. The PTAB, however, instituted review on only a subset of the challenged claims, and its final written decision in turn addressed only the instituted claims. SAS appealed that decision to the Supreme Court, arguing in part that it was improper for the PTAB to pick and choose among claims as it instituted, and that instead Section 318 required the PTAB to make a final written decision on all challenged claims, not simply on the instituted subset. Following its precedent from Synopsis, the Federal Circuit affirmed the PTAB's decision to address only a subset of the claims in the post-institution phase of the proceeding and in the final written decision, and did so over Judge Newman's dissent. SAS then appealed that question to the Supreme Court and framed the question presented as, does Section 318A require that the board issue a final written decision as to every claim challenged by the petitioner? I'm pulling the language highlighted there in red. Interestingly, although, as Rachel said, this might be of the two cases, SAS and Oil States, this may be the case with a greater practical impact on petitioners and patent owners who are before the PTAB, given the estoppel provisions in the statutory scheme and also the appeal rights. Those were things that we heard from counsel for SAS in the argument, that was a large portion of why they had moved on this issue, was in order to be able to have an appeal on the non-instituted claims, which otherwise would be precluded. Only two briefs were filed by amicus in this case, one on each side one in favor of SAS and one in favor of the PTO and Complement Soft. And the briefs themselves are very short from the amicus. One is 12 pages and one is 19. So the Supreme Court received only 31 pages of third-party briefing in this case, which is in stark contrast, as Jason explained earlier, to the amount of interest that was generated by Oil States.
Thank you, Kara. Oops. I did a similar analysis of the argument in SAS, and I think that in our initial discussions, when Trenton and Kara came back from the argument, they had mentioned it seemed the judges were a little quieter in SAS. Perhaps they were a little tired or possibly less interested for one reason or another. But it turns out actually there were 72 questions asked to the parties versus 77 in Oil States. And again, the split being 50-50 to the PTO and SAS. The questions to SAS came predominantly from Sotomayor, and perhaps this is one reason why the bench seemed a little quieter. It was much more consolidated amongst the justices, with Justices Sotomayor and Kagan making up far more than the majority of the questions to SAS, and only Justice Ginsburg, Kennedy, and Breyer chiming in to question SAS. And on the other side, the bench was much more active with questions to the Patent Office. Again, Justice Gorsuch leading the charge, followed by Justice Alito, who was more silent in the Oil States case, and then Justice Roberts making up the majority of the questions to the PTO. As far as topics go, this was a little less surprising, at least to me, than the Oil States case. The top topic amongst the judges was very detailed statutory interpretation, asking the parties, where's the support in the statutes for your position, and really trying to dissect what the congressional intent, if you couple it with the third one listed here, what was the intent in Congress in writing the statutes the way that they did, and what exact language did they use. The second category is what relief is sought, what the procedure is, and this maybe needs a little explanation about what that category means. There were several questions, a large number of questions about exactly what the parties were saying. How would this procedure category goes to exactly how this play out at the PTAB? What would the APJs have to do in an institution decision? What would they have to do in a final written decision? And how would that work? And what are some ways that you could propose that this would work if we take your position? And those questions were asked on both sides of the fence. And then there was some questions, especially in the beginning, and Justice Sotomayor pointed out that it seems like the relief sought by SAS would conflict with the Quozo decision, and isn't this just an end run around Quozo, which, as we all know, said that the institution decision is a non-reviewable decision on appeal. And then there were questions about how IPR actually works generally at the PTAB, and what this would mean for canceled claims. Would the judges at the PTAB have to address claims that were canceled in the amendment phase? And then questions about the facts of the case. And initially, Justice Ginsburg was asking exactly what SAS was looking for, just for a clarification of the relief that they were seeking and what their position was. And so that was basically the lay of the land and how this would play out. And perhaps statutory interpretation just isn't as interesting to many people, but certainly had just as big of an audience from us. And I will turn it over to Trenton to show you how we think this might come out.
Yeah, Rachel, thanks. So similar to our exercise in Oil States, we attempted to evaluate the questions and comments from the justices as an indication as to how they might rule, whether or not they would find it's permissible for the board to issue a final written decision on less than all of the claims challenged in the petition, or if in fact 318A requires all the claims challenged in the petition to be addressed. And I'll tell you, there was some back and forth. I think we had a little more back and forth on the SAS case and the justices' leanings than we did in Oil States. And after some discussion amongst the group, we arrived at what you see here on the slide as our feelings about the leanings with respect to SAS. And quite unintentionally, we realized after finalizing this slide that it was the exact same group as the same groupings that we had come out with in Oil States. So you can see that our opinion is there were 3 justices that seemed to be leaning towards allowing the PTAB to issue a final written decision on less than all of the claims in the petition. And there's one justice that seems to be pretty clear that that would be improper. So the same group as Oil States, the Justices Ginsburg, Kagan, and Sotomayor seemed to be in favor of an affirmance, and it was actually Ginsburg, once again, similar to Oil States, that kicked off the questions and didn't even let Mr. Cassanius, counsel for SAS, finish his roadmap before she asked the question, doesn't the provision begin if an inter partes review is instituted? And what she was asking about is the introductory clause to the statute in question here, 318. And what I took from this question, although she didn't get a chance to fully finish her question, was that Justice Ginsburg was trying to determine to what extent this conditional statement at the beginning of 318A would affect later statements in the statute, i.e., if the condition is that we're talking about an instituted inter partes review, then perhaps the claims that are addressed within that particular statutory section are claims that were instituted. Justice Ginsburg actually ended up sort of being the bookend in this argument. She asked the first question, and then she asked one of the last questions at the end of the argument. And particularly, she asked this question of, are you, the respondent, relying at all on the notion that this entire inter partes scheme is to give the agency a chance to take a second look to correct its error? Therefore, it should not be the petitioner who controls what the agency will consider. And I think what I would gather Justice Ginsburg is talking about here is somewhat of a reaction to the petitioner's position that it is the petitioner who should be the master of an inter partes review. It is the petitioner that's bringing the challenge, and therefore, in doing so, they should dictate the claims that are addressed in the final written decision. And I think what Ginsburg is exploring here is that perhaps it is actually the agency that is the master of what amounts to an error-correcting procedure. Justice Sotomayor followed Justice Ginsburg's initial question by jumping into what I thought was perhaps at the heart of the matter and something that Rachel had already mentioned about what exactly is the petitioner seeking. She said, I'm not at all clear what it is you're challenging here. And she seemed, in her questioning, as you can see, to think that the petitioner was asking for an end run around the outcome in Cuso and the Supreme Court's determination in Cuso that under 314D it's not possible to review an institution decision. And so Sotomayor repeatedly questioned counsel for SAS as to whether or not, if that was in fact what they were trying to do. Justice Sotomayor actually also asked what I thought was a particularly probing question that I put on the bottom of the slide here, where she said, could you, the petitioner, show me where anywhere in the statute the board is prohibited from directly initiating partial review? So essentially asking for SAS to indicate where in the statute the board is told that it cannot institute a partial institution. And Justice Kagan had a similar question as what you see on the bottom of this slide. She says, I guess here's my question. What language says that partial institution is not permissible? So at least these two justices were trying to explore the idea of essentially why not? Why would the board not be able to carry out this partial institution? And one of the arguments that SAS made that I found sort of odd, given their position, was that SAS counsel repeatedly referred to the statute as telling an elegant story about how inter partes review is supposed to work, and Justice Kagan used that as a springboard for her comment here at the top of the slide, where she said that, well, one of the stories the statute is written seems to tell is that it is of great discretion to the board with respect to the institution decision, and that it's a little bit odd that here's one thing you don't have discretion over when it comes to institution. Why can't you say these claims but not those things? Should we carve out that one thing? Essentially, Justice Kagan asking the question as to, well, if the statute gives the board so much discretion in many aspects of institution, it would seem odd to remove that one small thing from their discretion. So based on these comments from Justice Sotomayor, Kagan, and Ginsburg, we believe that they seem to be leaning towards a finding of the board's capability to provide a partial institution. And so, Carol, I'll turn things to you to talk about Gorsuch on the other side of that.
Thanks, Trenton. And so, as Trenton said, both Sotomayor and Justice Sotomayor and Justice Kagan seem to view the IPR statute as permitting the PTAB to do anything that was not expressly forbidden, whereas Justice Gorsuch seemed to view it in an inverse way and actually asked respondent to show him exactly where it said the PTAB could do and the director could do what is being done. And so he wanted authority for the proposition that partial institution was affirmatively permitted by the statute, which was, we thought, an indication that he was likely to find that Section 318A was not ambiguous and did require the PTAB to address all claims that were challenged in a final written decision. Beyond that divide, though, the other justices who we put in our unclear division weren't as sure about whether the statutory language was ambiguous or not. Justice Breyer, as you can see, said that the language seemed to favor petitioner but not definitely. Justice Alito asked whether there was ambiguity but also asked whether the statute would prevent the board from acting as it was. And Chief Justice Roberts, so he didn't seem to embrace the concept that the Congress would have deliberately made the statute ambiguous, did not indicate by his questioning whether he seemed to agree or not. And so we went back and forth on these justices and couldn't clearly place them on one side of the scale or the other. And Rachel, I think we have time for a poll.
Thank you. We thought it might be interesting, given the level of interest in this case, to find out what you as the audience think about these questions, and would like to do a live poll. We're going to give about 20 seconds to answer the question, and you should know that this poll won't show your name or affiliation to the audience. It will only show the aggregate response of the group in the result. So if you don't mind answering our question, which way do you think that the court will hold in oil states? Will they find that IPRs are constitutional or non-constitutional? Okay, I think it's time for the results. Hopefully you've submitted your answer. Wow. Okay, so it seems we have a general consensus. I can't tell you actually how many people answered the question, but we have an 88% constitutional and 12% non-constitutional. The follow-up question here is, which way do you want the court to hold? So if you could get your holiday wish, are IPRs constitutional or are they not constitutional? And again, your affiliation and your name will not show to the audience, only the aggregate response of the group. And I'll give you just a few seconds to answer this question. Okay, let's see the results. Okay, so 88% think that it's going to be ruled as constitutional, but only 60% of our audience actually wants it to come out that way. So that's a very interesting result, with 40% of our audience wishing that these proceedings would go away. And for SAS, which way do you think the court will hold? Will the justices require that all claims be in the board's final written decisions, or will the board be allowed to issue a final written decision on fewer than all claims? And I'll give you just a few moments to answer this question. Okay, hopefully everybody has their answers in, and let's see the results. Okay, so the majority believe that the board will be able to issue a final written decision on fewer than all claims, and of course this all hinges on whether we actually will have the proceedings or not as a result of Oil States. And similarly, if you could get your holiday wish, which way would you like the court to hold in this case? Do you prefer that all claims would be in the board's final written decision, or that the board would be able to issue a final written decision on fewer than all claims? Okay, let's see our results. Interesting. It seems we have an almost even split on which way we would like this to go. Before we begin the Q&A portion, and we have just a few minutes left for that, please take a moment to complete our brief survey. We strive to provide programs of value, and we would appreciate your input and to guide us in planning future programs. And as a reminder, to participate in the Q&A, click on the Q&A button, type your question into the Q&A window, and click Submit. We've been trying to answer some of these questions as we move through the program, and we'll try to get to as many as we can in the next few minutes. We have a similar question that we discussed with respect to Oil States, and this is for any of the three speakers. While we await a decision in SAS, what are some practical steps that the parties involved or becoming involved in IPRs could take?
Well, this is Jason. One thing I think you should do is preserve your arguments. If you are in a partially instituted IPR, the likelihood is that the PTAB is only going to issue a final written decision on the instituted claims. So, if you think that's wrong, you should preserve your argument there. I think this probably more affects patent owner strategy right now than petitioner strategy from the standpoint that if you know that your weakest claim is likely to trigger an IPR, and then all of the claims might end up coming along with that, under SAS, if they have to bring in all the claims into a final written decision, I think that has a pretty big effect on how you argue in your preliminary response, for example. Maybe arguments that you would normally put in there if you were inclined to argue the merits, the substantive merits of some dependent claims or something like that. Maybe you don't put those in your preliminary response. You don't provide that roadmap early. You wait until after you've deposed the opposing side's expert, and then you put that in your patent owner response. We don't know when the decisions are going to hit here. They could probably hit as early as January, most likely. I think we won't get these Supreme Court decisions until March, and it may even be as late as June. So you're kind of in a window where you're shadow boxing a little bit, but it's something to think about. How many cards do you lay on the table, in your preliminary response, if there's the possibility that you're going to get instituted on everything once claim one gets instituted. The other aspect of this is the district court side, where if you're trying to argue for a stay, and you're trying to show that this could, the IPR could resolve substantially all of the issues potentially in the district court litigation warranting a stay. The uncertainty around how the Supreme Court might rule here, I could see that maybe having some influence on some district court judges, maybe in favor of a stay, because right now some of the judges look at it and say, well, we want to know if they're going to institute on all the claims that were challenged that are relevant to our case here in the district court. And if there's now this possibility of pulling in all of the claims, maybe that concern goes away a little bit for them. Obviously, there's still uncertainty about how the Supreme Court will rule on this, but it may be an argument that's worth making in the interim.
Thank you, Jason. We are at 1 o'clock, and unfortunately, we need to wrap things up. To the extent that we can, we hope to answer your questions over email following the presentation. Thank you very much for attending today's webcast, Oil States and SAS Takeaways from Live Arguments Before the Supreme Court. This presentation will be available on demand in the next week. Please look for an email from us with access to the link. This concludes today's Finnegan webcast. Thank you very much for participating.